Welcome to Employment Law This Week. I'm George Whipple. On March 30th, a Texas district court struck down an Affordable Care Act mandate that required health plans to cover many preventive medical services, including cancer screenings and PrEP for HIV. This final judgment follows the judge's interim summary judgment opinion in September, in which he held that it was unconstitutional for the United States Preventive Services Task Force to determine which preventive services plans are required to cover without cost sharing. The judge also found that the requirement to cover PrEP for HIV violated the plaintiff's religious rights under the Religious Freedom Restoration Act. The Biden administration filed a notice of appeal the day after the final judgment came down. The judgment is presently effective nationwide, barring a stay on the decision. This decision means that employer-sponsored plans are currently no longer required to cover many preventive services, and if they do, they aren't required to cover them without cost sharing. In addition, employers with sincere religious objections to preventive services and medications like PrEP may no longer be required to cover them in their health plans. Again, this all could be subject to a stay of the decision pending appeal. The Department of Justice loses another No-Poach case. A jury in Maine has handed the DOJ its third consecutive trial loss in its efforts to prosecute naked no-poach and wage-fixing agreements, acquitting 4 home health care operators of wage-fixing and no-poach charges. The fact that these cases have made it to a jury shows that courts have accepted the DOJ Antitrust Division's legal foundation for them. Because the FTC lacks criminal enforcement authority, expect the Justice Department to continue its focused pursuit of these agreements on an antitrust theory. The trend continues next in Connecticut with another no-poach case from the DOJ. What does the end of the COVID-19 emergencies mean for employers? This will mark the end to a slew of citizen benefits, including requirements for health plans to cover testing and out-of-network vaccines. Employers are taking this time to reevaluate COVID-19 protocols and policies. State and local jurisdictions may have their own requirements and different timelines than the federal government, so employers should review regional and local laws to ensure they remain in compliance. That's it for this week. Thank you very much for watching, and we'll see you next time.